Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There's been a lot of discussion, comments, and feedback regarding if the state of Idaho's notice to seek the DP could be stricken from the record and therefore having the DP taken off the table in the event of a conviction in Idaho versus Kohberger. Could this be a possible sanction for the issues and the concerns that Judge Stephen J. Hippler raised May 15th, 2025, document and records hold order that went to the state of Idaho, where the court came out and said he believes that it's likely that a violation of the non-dissemination order that led to the network television special on the case that aired May 9th, 2025 was a result of misconduct on the part of someone associated with the state, either law enforcement or the prosecutorial team. Judge Hippler has stated in the order that he wants to identify the source of this issue and make sure that there's accountability. He says right here, he finds it is imperative to attempt to see that the source of the leak is identified and held to account. And he directed the state in this order and also the defense in a companion order that was sent to the defense to provide a list of all people who were known to have access to information and evidence that the court found sensitive information, not previously publicly circulated, that was reported that related directly to this case and the defendant, Brian Kohberger. There's some language in here that the court has used that seems to suggest that he would be inclined to take the DP off the table, providing this pure speculation and opinion. But when you see here in this order, where he says such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury. Mr. Kohberger has filed multiple motions to strike the DP, all of which have been denied. The court on April 29th, 2025, rendered an order on defendant's motion to strike the DP and adopt other necessary procedures, which charged the state with misconduct. Judge Hippler was told by the defense that Mr. Kohberger's due process rights have been violated and that he is seeking sanctions in the form of striking the DP. Judge Hippler, in denying this motion, said, because defendant has failed to show a discovery violation or due process violation by the state, sanctions are not warranted. Let's go back to the May 15th, 2025 order. You see this language that says that these ills, according to Judge Hippler, significantly impeded the ability to seat an impartial jury. An impartial jury is a requirement of due process. If you look at the 14th Amendment to the United States Constitution, that's where the Due Process Clause is located. And it says that when the government seeks to take away someone's property or life or liberty, that that person must be afforded due process of law. And due process of law requires three things: notice of what the government is intending to do, an opportunity to be heard on the matter, and impartiality. So, if the court has already gone on record and said, I'm not going to grant you a motion because you did not show a due process violation. It appears that the judge has found that these issues, the ramifications of this egregious misconduct, impacted Mr. Kohberger's due process privileges. There was a case that you might have heard of relatively recently, another high-profile case, another capital case in Idaho, State of Idaho versus Laurie Noreen Vallow, a.k.a. Laurie Noreen Vallow Daybell. That was prosecuted in Fremont County, and the judge there was Judge Stephen W. Boyce, district judge. He rendered an order on March 21st, 2023 in that case, granting defendant's motion to dismiss the DP and order striking the notice of intent to seek the DP. There was a proclamation from the bench on March 21st, 2023, and this written order memorialized the court's ruling that the defense's motion was granted. The order entered, struck the notice of intent to seek the DP. If you research this matter, the underlying reason that caused the DP to be taken off the table in that case not that long ago was a discovery violation. The state turned over requested discovery late, and the court found that that was a due process violation. The conduct that Judge Hippler is talking about here is so much more egregious. There were 3 orders in place, non-dissemination order. The first was implemented on day 4 of this case. It has never been set aside. State has never looked to set aside that non-dissemination order. The defense never did either. The media coalition went to the Idaho Supreme Court and also to Judge John Judge when this matter was in Latah County and attempted to get that non-dissemination order vacated, and they failed both times. I have been researching since this information came out to see if there was any other case like this, a capital case where this type of violation of a non-dissemination order, likely by people who are entrusted to uphold the law, as Judge Hippler stated in this order, I couldn't find one. Based on Judge Hippler's words, based on the precedent in Idaho in the Daybell case, and based on the fact that what Judge Hippler said in the order, he is looking to have accountability here, there stands a possibility that the DP could be struck from this case. If you have any comments, any feedback, please leave it here. If you like our content, I would appreciate it if you would hit the like button and also consider subscribing to the channel so that when our future content comes out, you will receive a notification. We will continue to follow this matter, and as further developments arise, we will let you know. This is Kathy. As always, thank you for joining us today.